implementation of Second Substitute House Bill 1515, which provides expanded alcohol service areas. We held a stakeholder meeting on Wednesday, and this is the second one. We're covering the same topics. If you attended previously, a lot of this will be redundant, but there may be additional conversations from and questions from folks attending. Our objective is to inform and obtain public feedback on draft rule language being developed to implement the bill, which creates 3 new temporary authorizations allowing for expanded alcohol service areas when certain conditions are met. We're in keeping with this feedback, the best way to get in touch with our rules team is at rules@lcb.wa.gov. I did put that in the chat, along with some other contact information as well, and we'll probably drop that in there periodically just so it'll be fresh for folks. A few housekeeping notes here. These meetings will be recorded and subject to public disclosure. The purpose of the recording is to make sure that we collect all feedback, and they will be posted on the rules webpage. While the Teams chat feature will be on, any written questions submitted in chat will be saved in the rulemaking file and will be subject to public disclosure. Questions and comments in the session's team chat will not be responded to in real time, but will be addressed at the end of the session, time permitting. So I'm going to go through the presentation. I just ask that folks hold their questions until I'm finished with it, and then we'll go through. We should have plenty of time. On Wednesday, I finished the presentation with about an hour to go, and that was more than ample time to answer questions and respond to comments. So participants will be muted and will only be unmuted when the session's facilitator enables their microphone. And so we ask that you use the raise hand function to be called on. And then again, if you would like to submit questions or comments to rules@lcb.wa.gov, that's another good way to get in touch with us. So what will we cover today? We're going to go over a review of the legislation. We're going to talk about information that's available for applicants now, because as we will discuss, the law is already in effect. It took effect on July 27th, so it's nearly a month now. We will talk about the rulemaking process and our timeline. Then we'll get into the draft rule and some key points and comparisons between the different authorizations. And then we'll have time for questions and comments. So let's jump right into our review of the legislation. Second Substitute House Bill 1515, passed by the Washington State Legislature during the 2025 session. I believe it was signed into law in May, and it took effect on July 27th, 2025. It creates 3 new temporary authorizations allowing for expanded outdoor and indoor alcohol service areas. And it will require new and amended LCB rules related to outdoor and indoor alcohol service, special occasion licenses, and catering licenses. And the law sunsets on December 31st, 2027, unless it's amended by the legislature. So while the bill was clearly catered to accommodate the FIFA World Cup in the summer of 2026, there are also much broader policy changes regarding alcohol service in public spaces, and there is a trial run aspect to it. There's a possibility that the legislature could vote to extend these expanded rules permanently, particularly if things go well. But for now, these authorizations are slated to end by December 31st, 2027. The first of these 3 authorizations is for expanded outdoor alcohol service in public areas for cities, towns, counties, port authorities, and unincorporated areas in a county. So local governments may request authorization for expanded outdoor alcohol service in public spaces in an area or areas of a city, town, unincorporated areas in a county, or port authority for special events or for an ongoing period through December 31st, 2027. So this first one is kind of the broadest of the authorizations under the new statutory allowances. The second is civic campus events in cities with a population of at least 220,000 inhabitants. These cities may request authorization for expanded indoor and/or outdoor events on publicly owned civic campuses through December 31st, 2027. And a publicly owned civic campus is defined as the buildings, facilities, grounds, lands, and spaces that are owned by a city, and they must be designated as a city center and used for civic, arts, cultural, sports, or other community and family events and activities. They cannot be more than 100 acres in size, and they are limited to 25 events per year, up to 7 of which may be multi-day events. So what we're talking about here, this is limited to the cities, the largest cities in Washington, which would be Seattle, Spokane, and Tacoma. And then the third authorization is for the FIFA World Cup in 2026 for fan zones and the host city. And so this authorization is only in effect between June and July of 2026 for just 2 months. And fan zones have been designated for Bellingham, Bremerton, Everett, Olympia-Lacey, Tri-Cities, Spokane, Tacoma, Vancouver, and Yakima, and then Seattle is an official host city. Games will be held at Lumen Field. So information available for applicants right now. As I mentioned, the law is already in effect. So beginning on August 27th, applications for these authorizations will be available on the LCB portal. And there's information for that up here. We have a new web page as well for expanded alcohol services. And then if you have questions related to licensing, if you're applying for a license and you have questions about the process, or what to submit or how to submit it, those would go to expanded alcohol service at lcb.wa.gov. So I do want to kind of highlight the distinction there. Right now, today, we're discussing the rules and we're seeking input on the rule language and that sort of thing, which is somewhat separate from applying for a license. So all that contact information should be in the chat there. I am also told that our licensing division is in the process of setting up a feedback session on how to apply for a license, because there have been some questions that came up after Wednesday related to that. So we will be sending out more information shortly on that. I think we're tentatively looking at September 4th, but that has not been finalized as of yet. So we have a law that's already in effect. We'll begin issuing licenses next week, but our existing rules don't support the new law and in some respects stand in contrast or contradict it. And as we'll get into, rule development takes time. So in the meantime, the Liquor and Cannabis Board has issued an official policy statement to provide guidance in the interim between the law's effective date of July 27th, 2025, and the adoption of rules which are expected to occur around January of 2026. So this brings us to the rulemaking process and our timeline. Rulemaking can be needed for a variety of reasons. Sometimes an agency sees an issue related to its mission that needs to be addressed, and the agency will initiate rulemaking on its own. However, rulemaking can also be necessitated by several other outside factors as well, such as public petitions, executive order by the governor, state or federal court decisions, or legislative implementation. And the nature, scope, and even requirements for rulemaking vary somewhat in each of these cases. So today we're talking about implementing Second Substitute House Bill 1515, which makes this a legislatively driven rulemaking project. Our elected officials passed a bill, which has now become law, and we are subsequently conducting rulemaking to ensure that the law can be implemented while adhering to our mission statement, which is to promote public safety, public health, and trust through fair administration, education, and enforcement of liquor, cannabis, tobacco, and vapor laws. So in this case, and anytime we're conducting rulemaking because of legislation, it's not really an agency's role to debate the merits or feasibility of the law. That's already been done by our legislators. And we at the LCB and other state agencies, as unelected public servants, cannot change, expand, or diminish the scope and scale of the law that has been enacted. So what then is the point of rulemaking? Well, typically, a given law will provide some degree of statutory authority to an agency to adopt rules that help to implement and clarify the requirements of the law. And in the case of the LCB, we also have relatively broad rulemaking authority over alcohol in general. So with respect to implementation of Second Substitute House Bill 1515, rulemaking is necessary to align existing LCB rules with the new statutory allowances. I'll also add that in addition to aligning existing LCB rules, we are going to be creating brand new rules as well. It's also necessary to clarify ambiguity in the law and to establish appropriate fees as required by the law. And so I put an asterisk in there because there are very few instances within the bill where the law explicitly defers to the Liquor and Cannabis Board to adopt rules. It's actually a fairly prescriptive statute already. There are several instances where it states that the LCB may adopt rules. But one thing that is specifically required is that the Liquor and Cannabis Board set fees to cover but not exceed the costs associated with implementation. So in order to comply with the law and begin issuing licenses as soon as possible, the fees have already been set based on our analysis of the bill and its implications in consultation between our finance division, licensing, IT, and director's office. And some of the agency costs that would be associated with this bill would primarily include licensing system updates and maintenance, as well as a significant additional enforcement effort. So I added the fees here. I think that's going to be important to a lot of folks. See that it's $1,700 per approved authorization for local governments for the first of the three authorizations. Licensees who are taking advantage of special occasion licenses under these authorizations would pay $185 per day. The localities would pay $1,500 per event on civic campuses, and the fan zones would be $3,900 per event. All right, so getting a little further into the rulemaking process, even though the law is already in effect and you'll soon be able to apply for a license, we've really only just begun on the rulemaking side of things. As I mentioned, rulemaking is still necessary and it takes time. It's not uncommon for even the simplest rulemaking projects to take several months or a year to be completed. And this is largely because the rulemaking process is bound by guidelines set forth in the Administrative Procedures Act, Chapter 3405 RCW, and related rules designed to ensure public access and transparency. The APA stipulates a three-part process for most rules and establishes minimum and maximum timeframes for certain aspects of each phase. So for example, a required public hearing cannot fall sooner than 20 days following the filing of a CR 102 or the CR 102 publication date. And we'll get a little bit more into what all that means as we go here. So for our timeline, what we've done so far, on May 7th, we filed a CR 101, which is the pre-proposal statement of inquiry. And that just notifies the public that we're going to be opening up our rules for amendments or for additions or any change in rule. And then excuse me, I got ahead of myself there. Okay, then on May 21st, it was published in the Washington State Register. When we filed the 101, we announced a month-long informal comment period and asked for folks to provide feedback. That ended on June 7th. And then on August 1st, the draft rules were posted and the stakeholder sessions were announced. I will note also, we posted the draft rules on August 1st, and I have subsequently posted an updated version because there were a few changes between when it was posted and now, and our understanding of things has changed slightly since we first posted it. So going forward, if we don't have to make a lot of changes to the draft, we should be pretty well prepared to request board approval to file the CR 102, which is our official proposal, on October 8th. If we're approved to do so, then we will file on October 22nd. And that's because the code reviser's calendar, it runs on a 2-week cycle, and there's closing dates twice a month. And then notice would be published in the Washington State Register on November 5th, which would line us up for a public hearing on December 4th. And then we would be prepared to request board approval to adopt the rule by January 7th of 2026. It would be published in the Washington State Register on January 21st, 2026, making the rules effective 31 days later, which would be February 7th of 2026. I would like to stress that this timeline is tentative. There isn't a whole lot of wiggle room. I mean, it seems like a long time, but with the code reviser's calendar and our board calendar and things like that, a few days difference can mean a couple of weeks where the timeline gets pushed out. So at the very least, we anticipate having rules in effect well before the World Cup takes place in the summer of 2026. So getting into the draft rule and looking at some of the key points, the table here shows in bold, those are the 3 primary authorizations that the new rules will allow for. And then the other 3 here, these are all new rules that we're creating. Then the joint operating plan, public engagement review, and the licensee sharing alcohol service area with non-licensee are ancillary to those 3 primary authorizations. And then we'll also have to update existing rules related to catering and special occasions licenses. So now we'll go over a few of the key points, and then I'll share the draft rule on my screen, focusing primarily on the new rules, and then we'll open it up for questions and comments. So bear with me, I've got several slides. Rather than presenting a big convoluted spreadsheet, I figured we'd kind of chunk it out here and talk about some of these things. So you can see the columns for expanded outdoor, civic campus, and fan zones. Those are the 3 primary authorizations. The expanded outdoor and civic campus here, you can see that is already in effect and runs all the way through December 31st of 2027. The fan zones is just for 2 months in 2026. Where does it apply? Expanded outdoor is the most expansive. It's really any city, town, county, port authority. Civic campuses only apply to those 3 largest cities in the state, Seattle, Spokane, and Tacoma. And then fan zones would have to be designated a fan zone by FIFA in this case. So expanded outdoor only covers outdoor alcohol service areas, whereas on civic campuses and fan zones, there are some provisions that allow for indoor as well. And you can see the localities differ slightly between the 3. There are no limit for the number of events for expanded outdoor. On a civic campus, as we mentioned, that would be 25 events per year, 7 of which could be multi-day events. And when we get into the rule, we'll talk about how we define those things as well. And then on for the fan zones, it would be a single multi-day event. We would assume a lot of places would be interested in doing it for the entire 2 months, but a locality would have the discretion to do it for a portion of that if they wanted to. So who can participate? As far as licensees, we define that in the rule. Beer, wine, spirits, restaurants, taverns, wineries, breweries, distilleries, and snack bars. And then that would all be permitted under the expanded outdoor. And then on civic campuses and fan zones, there are additional allowances for special occasion licensees and caterers. So the perimeter does not need to be approved by the board. It's just determined by the locality for the expanded outdoor authorization. But it does need to be approved for the civic campuses and fan zones. There's some slight differences for the barriers between the 3. And the barriers on slope, this is one of the areas we've updated the draft, and we'll get into that a little bit more. And as I mentioned, the statute's fairly prescriptive, but there are areas where they defer to the Liquor and Cannabis Board to set certain things. So 42 inches I have in blue, that's because that aligns with our existing regulations. It made sense to us to kind of keep some consistency there. And the same thing would go for the openings. Locality can determine the size of the openings for the alcohol service areas. However, if they don't, then the 10-foot standard would apply, which we see in other existing rules. So there are no signage requirements for the expanded outdoor, but there are for civic campuses and fan zones. And then for each of the authorizations, licensees can share an alcohol service area with other licensees subject to board requirements. The indoor would only apply on civic campuses, and then sharing with non-licensees would also apply for all 3 authorizations. And again, when we initially posted the draft, we didn't include that sharing with non-licensees provision for civic campuses because the statute doesn't explicitly say that, whereas it does for the other 2. But since that time, our understanding of the statutory intent has evolved, and our definition of a civic campus would kind of inherently imply that there would be non-licensees involved. So we're taking a more permissive approach there. Then we get into the joint operating plan. It's not required for expanded outdoor, but it is for civic campuses and fan zones. So any licensee that's going to participate under either of those authorizations, they would have to submit a joint operating plan that would cover certain things like how they're going to prevent underage sale and overservice, the ratio of alcohol service staff and security staff to attendees, training, the maximum number of drinks. There's another one where the statute defers to the Liquor and Cannabis Board. We set it at 2 because that's consistent with other standards. A locality would be permitted to limit that to 1, but it wouldn't be able to exceed 2 drinks per transaction. And then requirements for barriers and so forth. Then there are employee assignment requirements for the expanded outdoor. So an employee of the licensee must be assigned to, but not necessarily in the alcohol service area. There are some requirements around the line of sight. The allowances under this authorization are a little bit more permissive than our existing standards, and we'll talk about that as we get into the rule as well. And then the documentation required would be, are there adequate law enforcement patrols, and how are you going to keep the environment clean and free of litter and that sort of thing. So the Liquor and Cannabis Board could deny civic campus authorization based on certain criteria. It does not allow for us to deny the expanded outdoor or fan zones. And then licensees would be allowed to operate without a local permit otherwise required to use a public space for alcohol service and share an alcohol service area with another licensee without asking for LCB permission like they otherwise would for civic campuses and fan zones. And then lastly, regarding food service, under civic campuses and fan zones, licensees could sell and serve alcohol from an alcohol service area without food service unless or except the required food service on the licensed premises. If they're required as a restaurant to be selling food within the premises, then they would still be required to do so. So now I'll go ahead and share the draft rule. As I said, we'll focus mostly on the 3 main sections. And I'll point out where things have changed slightly since it was first posted. And again, we do have an updated version on the webpage right now. So if you want to follow along with that, you're welcome to do so. So bear with me for just a moment here. Okay, sorry about that. So as you can see here, we've got a table showing the new rules. In bold, again, those are the 3 authorizations, and then we have the 3 rules that kind of serve those authorizations. And then we have the amended rules. So I'm just going to kind of go over relatively quickly and highlight a few key points before we open up for questions and comments. So the expanded outdoor alcohol service authorization, we have a definition section. We define what an alcohol service area is, what a licensee is, and again, it's beer and wine restaurant, a spirits beer and wine restaurant, tavern, domestic winery, domestic brewery, microbrewery, distillery, or snack bar. The licensee definitions for the other two authorizations are somewhat more expansive to include special occasion licensees and caterers, but not for this one. So under 2, this is where the provision that allows for a licensee to share an expanded outdoor alcohol service area with another licensee. And then we kind of cross-reference here the existing rules. So there's an exception there saying that it doesn't apply to the existing rules. This is its own unique thing. And then under B, licensees may share use of an expanded outdoor alcohol service area with businesses that do not engage in the sale or service of alcohol, subject to requirements in the new rule that we have. As I showed you earlier there, we've got a new rule for licensees sharing alcohol service areas with non-licensees. And so we don't regulate non-licensees, but we can regulate the behavior of our licensees with relation to non-licensees. And then there's notification requirements here under C. Under D, all participating licensees are jointly responsible for any violation or enforcement issues unless we can demonstrate that the violation or enforcement issue is due to one or more of the licensee's specific conduct or action, in which case the violation would apply only to those that we identified. Under 3, it just specifies, that it could be the entire local jurisdiction or a portion of it. And under 3B there, a county can only be approved for the authorization in this rule as to unincorporated areas of the county. So King County can't make a decision on behalf of the city of Seattle. Thurston County can't make a decision that would implicate the city of Olympia. Let's see here. And then there's documentation requirements. So again, as we mentioned, localities will have to document how they're going to allocate resources, law enforcement patrols to keep everything safe and orderly. And then under 4B, that's related to keeping the area clean and tidy. So, what kind of trash services, how often are you going to be picking up trash and things like that. Under C, a locality has to identify the maximum distance apart for openings into and out of the expanded outdoor alcohol service area. And here again, we added the provision there that if a locality doesn't want to choose, then the 10-foot opening would apply because that's consistent with our existing rules. The locality would be responsible for any updates or changes to the alcohol service areas, and all expanded outdoor alcohol service areas must be enclosed by one of the following. So under 6A1, a permanent or movable barrier at a minimum of 42 inches of height. Again, that the statute defers to the Liquor and Cannabis Board to set that height, and that's consistent with other rules. It just didn't make any sense to us to recreate the wheel there. There's also provision in the statute regarding sloped conditions. So since the draft was first published, we did update it to include this here. It says a permanent or movable barrier at a minimum 42 inches of height. Naturally sloped conditions approximating a barrier of 42 inches or greater will also satisfy this requirement. So alternatively, a permanent fence-free demarcation could be used. And then we go into what the requirements for that would be. So if under C here, you use a permanent fence-free demarcation, it would need to be at least 6 inches in diameter, placed no more than 10 feet apart, and it would have to be visible at night. Under 7, an employee of the licensee must always be assigned to the expanded outdoor alcohol service area when patrons are present. So when an obstructed direct line of sight from the licensed premises to the outdoor alcohol service area exists, an employee with a mandatory alcohol server training, the MAST permit under Chapter 314.17 WAC, must be in the expanded alcohol service area at all times that patrons are present in order to monitor alcohol consumption. So that is a little bit more permissive than the existing regulations for outdoor alcohol. So right now, the existing regulations say that there has to be a direct line of sight from inside the premises. The statute requires something slightly more permissive. And so we're just saying that you basically have to be able to see the alcohol service area from somewhere on the licensed premises, right? So if a manager steps out back or a side door or something of that nature, that would suffice. And then under 9, a local jurisdiction approved for expanded outdoor alcohol service authorization consistent with this rule must submit results of a public engagement review consistent with WAC 314.03.214. So with all of these authorizations, the locality is going to have to conduct this review and submit it to the Liquor and Cannabis Board as well as the legislature. And we do have a separate new rule pertaining to that. And then 10 is the fee here. And under 11, we're stating that it runs through December 31st of 2027. So we're going to move on to the civic campus authorizations. You're going to see a lot of redundancy here. There, like the tables that I was showing, there's a lot of things that are shared, but there are obviously differences. We have our definitions section. And then as I mentioned on civic campuses, all the same licensees would apply, and additionally, special occasion licensees could take advantage of this authorization as well as those licensed to do catering. We go on to define what a publicly owned civic campus is. Again, it's only for cities with 220,000 people or more, so that's very limited. Then we stipulate only 25 events per year, 7 of which may be multi-day events. And then here's another area where the statute was kind of silent. What is a multi-day event? The intent, it's pretty clear, was not a multi-day event, could be 365 days, for instance. So we settled on 7 days. That seemed to make a lot of sense. These events can happen concurrently, so you could have multiple 7-day events in a row if you wanted to. And then 3 gets into the sharing of space with licensees. 3A, the board has to approve the perimeter here on a civic campus. There have to be security and physical barriers provided at all of the entry points. And we have to have notification for the civic campus at least 60 days before the event occurs. Then D, we get into the signage requirements. And then E is that joint operating plan, which has to be submitted by any licensee participating on a civic campus. We have new rules again under 314.03.213 that kind of flesh out those requirements for the joint operating plan. And F here is where we added, since first posted, if businesses that do not engage in the sale or service of alcohol are located within the perimeter of the approved alcohol service area, licensees must also follow all requirements in WAC 314.03.215. So again, originally, kind of more strict reading of the statute did not allow for licensees on civic campuses to share a space with non-licensees. But after looking at it a little bit further, we agree with a more permissive interpretation. So that will be permitted on civic campuses. And then 4 goes into the indoor spaces. Again, there's going to be a 60-day notification for that as well. Then the campus operator has to ensure security and physical barriers. There's the joint operating plan requirements once again. And then in 5, you'll see this across the board. All participating licensees that share the space are jointly responsible unless we can pinpoint that a violation occurred as the result of the action of one specific licensee or multiple specific licensees. There will be under 5B here an attestation. So any licensee will have to attest that they are participating in order to take advantage of this. And then they would have to all engage in the following. They operating without a permit from their local jurisdiction that may otherwise be required. That we went into that with the chart there. They can share an alcohol service area with another licensee without having to request approval like they normally would. And regardless of whether the licensee's property, parcels, or buildings are in direct physical proximity to one another, they could still sell and serve alcohol to customers from an alcohol service area without offering food service like they otherwise might have to. And 7, as I mentioned, under the civic campus authorization, the board does have the discretion to deny it based on various criteria, a failure to put up signage and that sort of thing. And once again, under 8, there is the requirement that a city that's taking advantage of this is going to have to submit a report to the legislature and the board. There are requirements, they have to reach out to various community members and things to get perspectives on successes and failures and that sort of thing. And here for the civic campuses, we see the fee of $1,500 per application, and it's going to run again through December 31st of 2027. And then the last of the 3 authorizations would be the fan zones. We have the definition section again, just like the civic campuses, special occasion licensees and caterers can take advantage of this as well. Under 2A, the fan zone authorization described in the section allows a fan zone to obtain approval for the board for expanded outdoor and indoor alcohol service for liquor licensees within an area or areas of the jurisdiction. So that jurisdiction gets to decide the specific parameters of where that's going to be. It's a single multi-day event in June or July of 2026. It could be that whole time, it could be a portion of that time, but it's only one authorization. So that would be something to keep in mind. And then under 3, we get into sharing an alcohol service area with other licensees. The board has to approve the perimeter. Once again, we see the security and physical barriers requirements. We do see primary licensee can be designated on behalf of all of the licensees, and we would have to see notification at least 60 days before the event begins. Then we see the signage requirements that are the same as for the civic campuses. And then under E, we see the joint operating plan, which refers back to this new rule that we have under WAC 314.03.213. And then under 4, we get into sharing of spaces with non-licensees. And then that's covered more thoroughly under WAC 314.03.215. And we see that same provision under 4B here of all participating licensees being jointly responsible unless we can pinpoint that something occurred as the result of the actions of one or more specific participants. There is also an attestation requirement here for the fan zones. And then 5 goes on to stipulate that a licensee can operate without a permit from their local jurisdiction that would otherwise be required. They can share an alcohol service area with another licensee without individually requesting approval like they otherwise would, regardless of whether the licensee's property, parcels, or buildings are in direct physical proximity to one another, like exist for the current rules. And once again, licensees will be able to sell and serve alcohol from an alcohol service area without offering food service menu options, except that any required food service must still be provided within the licensed premises and in any pre-existing alcohol service areas that operated prior to this authorization. And again, we see this public engagement review that has to be conducted. There is a new rule section for that. The fee for the fan zones is $3,900 per authorization, and this one is only in effect until August 1st of 2026. So that brings us to these ancillary new rules that kind of serve the 3 new authorizations. So you've got the joint operating plan. We have the definition for an alcohol service area. Under 2, it just stipulates that this applies to civic campuses, or 2A, and under 2B, it applies to fan zones. And then we talk about requirements for submitting the joint operating plan. It has to be electronic. That's all going to be on the portal, and the link is available in the chat there. We'll need at least 60 days in advance of the event. And then the requirements that the joint operating plan has to contain, again, how licensees are going to prevent the sale and service of alcohol to minors, how they're going to prevent overservice to people who appear to be intoxicated, the ratio of alcohol service staff to anticipated number of attendees, as well as the ratio of security staff to anticipated number of attendees. And so this is an area where in statute, it stipulated that the Liquor and Cannabis Board may set these ratios, but we're not required to. And when we examined that, we felt like a one-size-fits-all ratio does not make sense. In some environments, one thing might work, whereas in other environments, another might. And a locality is really best prepared to determine what makes sense for them. And so we expect due diligence on the part of the locality. They are going to have to report out on successes and failures. So it's in their best interest to come up with a reasonable ratio there to prevent overservice and service to minors and orderly conduct and cleanliness and all of those things. So there's training requirements. The number of alcoholic beverages, again, we set it at 2. If a locality wants to make it just 1, they're welcome to do so, but they would not be permitted to exceed 2 beverages per transaction. We would want some explanation of how you can identify an alcoholic beverage versus a non-alcoholic beverage. Typically the containers are going to be different, but if there was some other strategy, we would want an explanation of that. And we would want to know about the barriers. There is some discretion to localities, as I mentioned, whether it's a permanent or movable barrier, and that sort of thing. Let's see. Then there's provision for how licensees will maintain separate storage of products and separate financial records. If licensees share any point of sale system, they must show how they will independently maintain complete documentation and records for the shared point of sale system, showing clear separation as to what sales items and categories belong to each respective licensee. We'll need to see a map of the alcohol service area. At the very least, we want to see where north is so that we can get an idea of what we're looking at. And the map would include the locations where alcohol will be sold or served, where the barriers are. We talked a little bit about sloped areas. So if a sloped area is serving in place of a permanent barrier, we want that indicated on the map. And then, of course, the entrances and exits, as well as public streets adjacent to the alcohol service area. And then 314.03 is the public engagement review. I don't think I need to get into too much detail on this, but again, there are requirements, and any locality that's participating here is going to have to do a review. It stipulates here that they're going to have to reach out to local organizations, individual residents, businesses, others in the local community. And then the things that they're going to have to examine would be, were there adequate local resources for the law enforcement and trash services and that sort of thing. And then under C there is going to be a cost benefit analysis. So, it cost a certain amount of money. We brought in how much money, we had these wins, these kind of issues. So we'd want to see, was it worth it, essentially? And this is going to be due by September 1st of 2026. And then the last of the new sections, as mentioned, licensees sharing alcohol service areas with non-licensees. There are definitions there. So only licensees authorized for expanded alcohol service consistent with these three new authorizations may share an expanded alcohol service area with non-licensees. We'd want to see a primary contact or licensee notify the board of the following prior to sharing the area with a non-licensee. A floor plan of the shared alcohol service area, identifying where those non-licensees are, how alcoholic beverages served by the licensee will be kept in a unique beverage container, where licensee liquor will be stored, and how access to that liquor will be exclusive to licensees and their employees. So, even though non-licensees will be involved, if they don't have a license and they don't have mass trained staff, we don't want them handling alcoholic beverages or serving alcoholic beverages. And all participating licensees are jointly responsible. Again, that's the same provision that we saw in the other rules there. And then, as I mentioned, in addition to the new rules, we've got a few existing rules that we needed to update, really just to allow for these new authorizations. So we see an exception here, the caterer's license rules, except as permitted in the new rules here. And I believe there was one other, yeah. So under 10 in the existing catering rules, we see that for events at a civic campus authorized under the new rules or events at fan zones, participating caterers must attest to joint responsibility as submitted by the campus operator on the local authority. And then we've got fees that we're updating in the existing rules. And this is actually not part of Second Substitute House Bill 1515, but instead another new bill that passed at the same time, Second substitute, Senate Bill 5786, that requires the Liquor and Cannabis Board to update all of our fees. So essentially all of our fees are increasing per statutory requirement. It's already the law, it's already in effect. So since we have this section of rule opened up, we are updating that section as well. And then we see okay, that's the existing fee there that's being increased by because of 5786 as well under 14D. And then we have, I mentioned a few times, existing rules related to outside or extended alcohol service. And we really just kind of cross-reference those to say that if you're operating under these new authorizations, this rule doesn't apply, see that rule. So you can see 7, we added this exception there. And basically the same thing with the special occasion license rules. We're just adding exceptions. If you're operating under these new temporary authorizations, you need to refer to those rules. We are updating the fees related to that other new bill as well. And then we have the new fee as part of second substitute House Bill 1515 of $185 per day for if operating under the new authorization. We see just minor amendments here to accommodate for these new authorizations. We did add a provision referencing the provision in the new rules regarding the board's discretion to deny applications based on repeat violations. And I think, yeah, here's more exceptions that refer to the new rules. And that brings us to the end. So with that, I think we can go ahead and open up for questions and comments. All right. Looking in the chat here, I don't see anything in the chat. It looks like there's a raised, okay, there's one. All right, one, expanded outdoor authorization. Is the application fee per year location, or is it a limited time frame? So as I understand it, the locality is going to be applying, and they stipulate the duration of the expanded outdoor alcohol service areas and the perimeter of those areas. So if they wanted to change it or update it, there would be an additional fee, as far as I understand, but otherwise it would just be the one fee. For civic campuses, and again, if our licensing folks have a different understanding of something, please feel free to chime in. I see Desiree there.
Yeah, thanks, Kevin. And you're right. If the local wants for expanded outdoor services for the entire period or a length of period, that's a request. That's one authorization, and that would be a fee. Let's say the local is not ready to commit to that time frame, but they want to try this for a one-time event. That fee would be the same for that one authorization. And if they said, oh, this was successful, we want to extend it, or we want to have a second one, let's say, in the fall or in the spring, that would be an additional authorization.
Thanks, Desiree. Number 2, civic campus. Who applies for the permit since it is event-based? The jurisdiction, the property operator, or the event producer? It's the responsibility of the locality, the local jurisdiction. They would be able to designate somebody else to apply on their behalf if they chose to do so. So for the third question here, Civic Campus, the stakes are very high. Is there provision for notice and opportunity to cure if one of the participating licensees makes a mistake? So I'm not really sure. There is going to be enforcement staff on hand. Again, if there was a violation that could be isolated as the result of one particular licensee, then that's who would get the violation. Um, all participants would be responsible if we weren't able to pinpoint that, which would have implications for everybody participating. Um, so I'm not sure if I could answer it any more thoroughly than that. Um, so I'll move on to question 4 here. Can a local jurisdiction adjust exiting of the enclosure if the requirements are different than LCB requirements? So again, in the provisions there, um, let's see, adjust exiting of the enclosure. Well, so the local jurisdiction would be required to set what those parameters are, and they would have to notify the board if they wanted to make adjustments. And number 5, for the Civic Campus and fan zones, is there a licensing fee to existing brick and mortar licensees, or is the layering of the authorization plus license fees only applicable to temporary licenses, catering, or special occasion licenses? So as I understand it, and again, we might want to hear from licensing on this, but my understanding would be that this is a separate authorization and an additional application would be required of licensees that are operating in a civic campus or a fan zone, because there's a unique license under these authorizations, even though they're both called a catering license or a special occasion license. Um, they're unique to these authorizations. So is that am I understanding that correct, Desiree, or somebody else from our licensing team?
So if I understand the question correctly, and bear with me if I did not, Gretchen, please feel free to raise your hand to come off mute. So the question is there a licensing fee for participation in civic campus and fan zone events for our existing licensees? So those folks that currently own spirits, beer, and restaurants or taverns, which are permitted to participate in these activities by this bill. So the answer would be no. They would join in the joint operating plan. They would be sent an attestation that they agree to the joint responsibility, but it would be an added activity on their existing license, which would not have an additional fee. The special occasion license, of course, is different than that because, as you know, special occasion licenses, those are not necessarily like our regular established restaurants, but they're for these special events, and therefore there is that fee that's associated with that. So in general, we're talking if the local authority comes to us for a civic center event, they would request that authorization and pay that fee. And any special occasion licenses that participated would also pay that fee. Existing licensees would just add that activity to their current license. And I see Gretchen's hand up, so I may have missed the boat.
No, I think you actually, Desiree, thank you. I think that answers perfectly. I'm trying to, as you can imagine, sort of parse out kind of the two aspects of this, which is the civic campus authorization and kind of what that means as a whole versus like in those instances when we may want to look at how do we figure out commingled licensing with existing licensees. So just I was trying to parse that out. So thank you.
Yeah.
I think
and I hope you'll
that answered
participate
that.
on the fourth if you have more questions about process. I know Kevin really wants to focus on rules, but thank you for letting me chime in.
Yeah, thank you for your question, Gretchen. And thanks, Desiree, for providing a more thorough response there. So let's see, where were we? 6, fan zones. Is there a multi-day event limit for fan zones the way there is for civic campuses? So no. So the authorization can be for the entire 2 months of June and July 2026, or it can be for a portion of that, and that's determined by the locality that's submitting the application. However, the statute does say that it is for a single multi-day event, right? So if the locality stipulated that it was just 1 week, they wouldn't be able to then apply for an additional week within that time frame. So, I would say if there are going to be ongoing events, it would be to the locality's advantage just to apply for the entire 2 months. And 7, joint operating plan. If commingled licensees, is there a need to differentiate? I'm not really sure if I understand that question. Let's see. So with the joint operating plan, a single primary applicant can be designated to submit that information. It would have to include an attestation by anybody that's participating. I'm not really, I don't know if, feel free to chime in if I'm missing the point here. I'm not really sure exactly what the question is getting at.
Sorry, I feel like I'm hogging a bunch of airtime. This is Gretchen with Seattle Center.
That's all right.
So what I was trying to get at with the joint operations plan question is, in one of the updated rules, 314.03.200, when you have multiple license holders having a shared service area, it talks about having some sort of there's the requirement to have alcoholic and non-alcoholic beverages being in distinct containers, but in that particular rule, it had language around alcoholic, like you needed to be able to identify which licensee had served which beverages, basically. And I didn't know if that applied to the if that needed to apply in a joint operations plan between multiple licensees. Does that make sense?
Yeah.
I'm just wondering if the 314.03.200 also applied in the case of these joint operations plans for these special authorized areas.
So just the new rules for the primary authorizations, that would take precedence over the existing rules there. Does that make sense?
Yes, it does. Okay, thank you.
Okay. And then if commingled licenses aren't used during a civic campus event, say just a single caterer's license, a single expanded service license, or a single special occasion license, will a joint operating plan be required?
I'm jumping in for you this time,
Sure,
Kevin. Just
please do.
Without
Yeah.
you asking me. Thank you, Gretchen. I appreciate these questions. Look forward to working with you. So if it's only one, I know that the sense of joint doesn't make sense, but we still have a lot of great questions that we need to make sure that we have, one of the reasons I love that this program is being run under our mandatory alcohol server training and responsible vendor program manager is because, of course, we want to ensure public safety. And so we will still require an operating plan, and it will be called a joint operating plan for civic centers, as well as a site map, so that we have those details available to us for the review to approve that authorization, as well as for our enforcement to know what they will expect when and if they need to, be attending.
Thanks, Desiree. Okay, so that's all that I see in the chat there. Are there folks who would like to raise their hand and ask questions verbally? We'll give it just a couple of minutes in case something else comes to mind while we're here. We've got time, but if if there aren't any questions, we can certainly end things, and I will put up our contact information as well. After today's meeting, we're going to be taking the feedback that we get. We're going to look at the draft rule to see if there's any additional amendments that we need to make to the rule prior to moving forward with the official proposal. Again, I think licensing is preparing to hold a feedback session as well related to the process for applying. And that's tentatively scheduled for September 4th. I see Desiree put the email address for questions related to licensing there in the chat again. So again, we'll just give it a few more minutes here. It looks like Nicola is raising her hand. Let's see here.
Yes, so more details to come, but we will be holding it Thursday, September 4th from 9 to 10:30. And we'll be sending notification out and more information very shortly.
Great, thanks.
Thank you.
All right, and so we'll just hang on for a couple minutes longer, just in case anything comes to mind. Oregon Beverage Services here. We provide service with similar type service all over Oregon. Please reach out to me with questions. Okay, great. Thank you, Heather. Okay, let's see here. Just want to put up our contact information real quick here. And I do see there's another question in the chat. Sorry, we were late. Clarify that service areas may use both barriers and fence-free demarcation and allow flexibility in barrier height on sloped sites without minimum height requirements as intended by the bill. Yeah, I think that the draft rules that we have do accommodate that. There could be a combination of permanent barriers and fence-free demarcation. There is the provision there for sloped barriers as well, that we wouldn't require a minimum height as long as it's approximating a 42-inch barrier. So to answer your question, yes, the rule does accommodate those things. No worries at all on the late questions. All right, we got another one here. We're interpreting the bill and rule as not matching. The rule states that a direct line of sight is required. However, House Bill 1515 reads, an employee of the licensee must be assigned to, but is not required to be in the outdoor alcohol service area at all times that patrons are present. A direct line of sight is not required from inside the licensed premises to the outdoor alcohol service area. Please clarify the reasoning for reinstating restrictions that House Bill 1515 has eliminated. Okay, so the section that you are quoting here regarding a direct line of sight okay, I'm sorry. So the existing rules for outdoor alcohol service do require a direct line of sight from inside the licensed premises. The statute does say that a direct line of sight is not required from inside the premises. It does provide the Liquor and Cannabis Board authority to make sure that the rules comport with existing regulations as well. So we're not saying that you have to have a direct line of sight from inside the building, but we are saying that you have to be able to see the service area from somewhere on the premises. So that is, in our interpretation, within the provisions of the bill. It is more permissive than the existing regulations, but there does need to be some sort of oversight to ensure that minors aren't being served, that things are orderly, that people aren't being overserved, and that sort of thing. So again, the new authorizations allow for a more permissive situation there with regard to the line of sight. And then the requirement that expanded service be within the site of an exterior entrance is unclear and can be challenging for corner cafes with doors on one street, but sidewalk cafes on multiple sides. It is not clear whether this refers strictly to frontage, a distance requirement, or the entire alcohol service area as recognized by LCB. Consider clarifying whether line of sight from windows qualifies and allow flexibility in siting to accommodate public plaza cafes in similar contexts. So, I mean, I kind of got to that with my prior response. Based on the way that the new authorization rules are written, a window would be sufficient. But we will certainly look at that, and make sure that it's clear and make sure that it is in alignment with the statute. All right. So, sure thing. We'll hang out for just a few more minutes, and then if no one has any questions, we'll finish it up and let you all have your summer Friday afternoon back. It is beautiful out there. All right. Guess we don't really need to prolong the awkward silence. I'll go ahead and say that we're good to conclude. Again, just want to reiterate next steps here. We're going to collect feedback. We're going to review the questions and comments that people have provided on Wednesday and today. We'll look at the draft and see if updates need to be made. And then we will be looking forward to the official rule proposal, which we're tentatively scheduling for October. I think that there's a good likelihood we can hit that target, which puts us on track to have rules adopted in January 2026 and an effective date in February of 2026. So with that, thank you all for your participation. It's greatly appreciated. If we want to have rules that make sense for everybody, we need everybody's participation. Thanks for being here. And if you have any other questions or comments, rules@lcb.wa.gov. That's where you send them to, and we'll be sure to get back to you as soon as we can if we hear from you. So thanks, and everybody have a wonderful afternoon and weekend. Thank you so much.